More than 100 staff members from the City of Johannesburg will be without jobs. The city has decided to not renew their contracts, a decision which has been slammed by many. For more on this, we're joined now by Advocate Mojalefa Motalane from Motalane Attorneys. Advocate, thank you very much for your time this afternoon. A very interesting story, this one. If we look at the conversion of these positions from fixed term to permanent, it seems at the heart of it, everybody, it's either an open secret that in most instances one would assume that a political principal and the political office bearers would have contracts that are aligned with his term as a political principal. But in this instance, they were converted to now permanent. But procedurally, particularly legally, one would wonder if there could be an issue here, because we heard that the City of Johannesburg is saying that this is more of a compliance issue, not necessarily a labour issue. What is your take on this matter? Mr.
Good afternoon, Mfundo. Yeah, hi, can you hear me?
Yes, I can hear you now. You can continue. Your take.
Thank you. Yes, I wanted to just indicate that I think in looking at this particular issue, one has to look at the contextual background that basically, leads us to this particular situation. So the political relationship between these particular positions and any administration is a matter that goes back to 2012, when in fact a delegation of authority was issued by the council authorizing the mayor to act in certain capacities, which is include to make determinations around the staffing requirements of the city. Now, in that particular instance, what then later transpired, and this is something that has happened in various administrations, where people have been employed within a fixed term contract basis. Those positions then subsequently, after a particular period of time, for the reasons that obviously the mayor and the mayoral committee would have determined at the time, to then convert those positions into permanent appointments. So that's basically what we're talking about at this particular point. The fact that you have, in fact, full-time employees of the City of Johannesburg, whose positions, relate to things like a driver, amongst others, appointed as full-time employees of the city, who now are told that they somehow need to then have their positions reverted back to a contractual, arrangement, which in fact does not arise, because even those contracts that we're referring to have long since expired. So these contracts, in fact, specifically came to an end in September of 2021. And these people have been in those positions, of employment before that particular period.
But Mr. Mojalefa, we know the position of the city now. They believe that it was incorrect to actually convert them. So one would say if there is some sort of legal avenue for them to maneuver, it would be something that they would explore. Are you aware of the legal opinion they got to somehow go through this process? Because one would assume that if the city had taken a decision, the predecessors would have taken a decision, one would assume it is functus official, that decision is final and binding. And one would assume that the next step for this current administration would be then perhaps to go review and set aside. Is that correct or not? Or even this matter would have to go to council, where they rescind the previous resolution and then they have another resolution. How would it work?
Yes, so thanks for that background, and you're absolutely correct. So this particular decision, is binding on the city. It's binding on the council of the city, unless set aside and reviewed by a court of law. Now, that's in terms of the legal principles that have been clearly, outlined in what is referred to as the Odekral case. So the issue, therefore, revolves around the kind of authority the city has if it has somehow came to a determination that this conversion, in fact, I interestingly noted that you said that the conversions were incorrect. You see, and that's the issue, that is right up over and above everything else. What we are concerned about is the legality. Whether was it legal to convert those particular positions or not. And our view is that it was absolutely legal. Now, whether it was incorrect or not, making it wrong or right, that's another determination which could be based on other reasons. However, what we know factually is the fact that a legal process was followed by the predecessors of the current administration to legally convert fixed contracts of employment into full-time employment opportunities. Now, in order for any future administration to then, would want to reconsider to reverse that kind of decision of another standing council, they would have to approach a court of law. And I think the third aspect you mentioned, that the council may have to decide to do so. So they may, what they may decide is to take a considered opinion based on an investigation. That would have also included points of views and inputs, from our clients, and then make a determination in council that that particular conversion would now have to be reversed. And in order to do that, it may only be done by a court of law. The council itself does not have the authority to make that decision.
Mm-hmm. Now, speaking of your clients, the workers in this case, were they consulted fully or even afforded an opportunity to make representations that if a process was going to take place where perhaps the city stated that we're taking this matter back to council, we want to rescind that decision to convert your positions but make submissions to us, what is your take? Was there ever such a process?
Absolutely not. Our clients did not have the privilege or the opportunity to participate in any process whatsoever that so directly affects their interest and their rights. It is also a requirement in terms of Section 3 of PAJA that interests of parties have to be considered in arriving at this particular kind of decision. And our clients were unfortunately not, consulted as such. They merely received notices following the council resolution of February this year, giving them a notice that their contracts have now been rescinded as a result of the rescission of the initial conversion process. And therefore, they've got, I think they were given 48 hours to submit any representations, as to whether they agree or not with this particular view. We then, of course, addressed a letter to the City of Joburg indicating that the periods that were indicated were wholly unsubstantial. We then got an extension for the 3rd of March. Which extension was then withdrawn actually a few days before that. We nevertheless insisted that we were going to submit on the 11th of March, which our clients eventually did. And in those representations, of course, we raised the lack of consultation as one of the most primary issues that makes this entire process rather flawed.
Mm-hmm. So where to from here? Because you guys still have some level of inconsistency, or there's a dispute between you and the city insofar as who are those with an interest in this matter. They say it was certainly not the workers because it's not a labor matter. This is all about compliance. They are focused on compliance, but you say that there is some sort of an interest that is accrued because these people, these workers, rightfully held positions that were permanent, and now those benefits or that right would be infringed. So where to from here if you're just not in agreement as to what is the real issue, a labor issue or a compliance issue?
Yeah, or even a legal issue, which is our point, in fact, that all of these processes revolve around, clear legal principles and a regulatory framework that determines how such decisions must be arrived at. It is very important, for the stability of our public administration that decisions such as these need to be taken within a context and a regulatory framework that can, meet the muster of the Constitution, which unfortunately is not the case currently. We have effectively received correspondence to the effect that the city is going ahead with its decision, and we are at this point, consulting with our clients to then make a determination as to which appropriate forum that this matter, will now go to. We obviously are within the regulatory framework of the bargaining council, the Labour Court, as well as the High Court. So we will then make a determination as to which is the appropriate forum. And once that particular determination, which I think it will be made this afternoon, as to which particular forum we are going to be pursuing this matter for urgent appropriate relief.
All right. Mr. Mojalefa, thank you very much for your time. That's Mojalefa Motalane from Motalane Attorneys. Now, still